Hi, everyone. Welcome in. We'll get started in just a moment. Great to see all of you for our final summer school session of the summer. Super exciting. All right, we'll go ahead and get started. Hello, everyone. Thanks for joining us, and welcome to the Environmental Law Institute's final summer school session of the summer. We do have a bonus session. I'll talk more about that in one second. But for now, we have our session on hazardous waste and sites. My name is Sarah Viken. I'm the manager of educational programs here at ELI. And we will be having a very special back to school edition of summer school. This will be taking place on September 10th. And it'll be featuring ELI's very own Christine Perry, who some of you may remember from our very first career summer school session back in June. It's going to take more of an international approach and focus on human rights in the environment. It's not on our website yet, but definitely do stay tuned for all of that. It should be posted very, very soon. But today we're closing out our summer version of summer school on a high note with three fantastic panelists who have so generously volunteered to share their time and expertise with us. On behalf of ELI, thank you so much to Martha Thompson and Craig Johnson, and to Kevin Murray, who will also be moderating today's session. Now, before we get started, I do want to take a moment to encourage you to fill out a really short survey we've created about your summer school experiences. We've had a lot of really great conversations at our in-person sessions, and we wanted to give everyone a chance to share your thoughts and feedback with us so that we can improve summer school in the years to come. We're also looking to really expand programming like this and maybe do more programs throughout the year. So your thoughts will really help us figure out how to expand this programming and how to make it the most useful to all of you. The survey is anonymous and all of the questions are optional. So if you feel so inclined, please take a look, and it would really, really help us out. The link will be in the chat, or you can scan the QR code now. Back to today's program. Following the presentations, we will be taking audience questions. Please submit any questions you have throughout the programs using Zoom's Q&A function. You don't need to wait until the end. We definitely encourage you to use the chat for observations, comments, but if you do have any questions, make sure to also put those in the Q&A to help us keep track of them. And as with all of our sessions, today's webinar will be recorded and posted on the event webpage and to our YouTube channel within the next few business days. Now, before we get started, I want to introduce you to our wonderful moderator. In addition to doing some of the teaching today, Kevin Murray will be taking on those responsibilities as well. Kevin is an environmental law partner with Holland and Hart based in Salt Lake City, Utah, where he's been the lead attorney for billions of dollars of acquisition and development of environmentally challenged assets worldwide, including many Superfund sites. His practice focuses on managing environmental liabilities, repurposing real estate assets, remediation, and planning. Leveraging more than 40 years of experience, Kevin is one of the nation's leading redevelopment attorneys with experience in CERCLA, RCRA, state hazardous waste laws and related programs, and substantial experience with uranium mine and mill remediation and decommissioning. He's also the president of the American College of Environmental Lawyers, in addition to serving on multiple boards and working very closely with ELI. Kevin is also an adjunct professor of real estate development and finance at the University of Utah and Brigham Young University Law Schools, having taught since 1990. Thank you so much, Kevin, for joining us today. And with that, I will turn it over to you to get us started.
Thank you, Sarah. I didn't want to acknowledge that I've been doing this for 40 years, but we'll go there. I'm honored today to join a panel with Martha and Craig, and I will do a brief introduction of both of those. I'm going to suggest that this introduction for both is not sufficient, and we'll invite all of you to take a look at the bio links that are included in your materials. Martha is a partner at Baker Bott's Environmental Safety and Incident Response Group in DC. She's been at Baker Bott since graduating from Michigan Law School in 2012. Martha's practice includes both regulatory work, including advising companies on compliance with RCRA, as well as CERCLA cleanup-related regulation and litigation. Her litigation work includes CERCLA cases that range from the simple two-party to the more complicated 100-party plus Superfund sites. In March 2020, Martha was part of a CERCLA team litigating a case in person in Texas. The trial was paused midway though in April 2020 and resumed remotely in May 2020 mid-pandemic. The Baker Botts team ultimately secured a $20 million judgment for their client in that litigation related to cleanup costs their client had spent on the contaminated site. So we welcome Martha to the panel. Craig Johnston is a professor at Lewis and Clark College. Before Professor Johnson joined the faculty in the fall of 1991, he practiced in Boston, Massachusetts, and Portland, Oregon. As Assistant Regional Counsel with the U.S. Environmental Protection Agency in Boston, Craig worked on major enforcement matters under both CERCLA and RCRA. In Portland, he founded the environmental section of the Perkins Coie Portland office and represented clients on compliance and litigation matters. In 1987, he was awarded the EPA Bronze Medal for commendable service. In 1985, he received the Bernard F. O'Rourke Award from Northwestern School of Law of Lewis and Clark College for excellence in the field of natural resources. Professor Johnson has published numerous articles in the field of environmental law and co-authored a casebook that many of you are probably using on hazardous waste law published by West. He's also an avid runner and the organizer of the cross-country relay event. And on the heels of understanding that Professor Johnson is a runner and that we're in the middle of the Olympics, I can't help but note that we're honored to anchor the ELI summer school team with Section 8 on hazardous waste sites, and we'll proceed from there. Okay, can we have the first slide, I think? Our agenda today is to talk about basically two fundamental laws. I understand that the opening or the title of this program is hazardous waste. That's generally covered by two significant federal statutes, and we'll mention a little bit more later about state counterparts. But the Comprehensive Environmental Response Compensation and Liability Act, or CERCLA, as many of you are familiar, is responsible or covers response and remediation for hazardous substances. The second act that we'll be spending time on today is the Resource Conservation and Recovery Act, or RCRA. RCRA fundamentally regulates the treatment, storage, and disposal of hazardous waste, corrective action associated with that disposal, and it's unique in that it is where we find the underground storage tank regulations across the country, which we will just mention briefly today. It is with these two acts that we have most of the hazardous substance regulation in the United States. Please note two fundamental differences between the acts from the get-go. The first is that CERCLA regulates hazardous substances. RCRA regulates hazardous waste. That differentiation is significant with regard to the applicability and the jurisdiction of both of those acts. Next slide, please. So let's start with CERCLA, and Professor Johnson's going to cover most of this, but it's been my task to kind of give us a background on the original objectives of CERCLA before we launch into its subtleties. Often at this point in the program, I pull up a news clip from a Cincinnati news station that identifies, the news clip is actually identifying an anniversary of the Clean Water Act. But in the process of doing that, they have several clips that identify the Cuyahoga River spontaneously bursting into flame. The Burning River, I think there's a beer in Cincinnati called Burning River Beer that is available for most people, and some songs that were written during that period of time. CERCLA was drafted and adopted at a point in time that we had quite serious environmental issues across the country. I'm not meaning to demean those that we may have today, but back then it was clearly an issue. We had river systems, we had land and disposal sites that were all posing significant issues to the country. One of the clear objectives of CERCLA on the front end was to provide a system to rank those according to the risks they pose. So again, you've got to put yourself in the position of the early 1980s when CERCLA came around. We had thousands of these sites that were well, I just mentioned you had a river bursting into flames. We had all kinds of issues that were extremely serious, and probably some that might be argued to be less. But one of the objectives of CERCLA was to create a system that would allow us to rank those sites so that the most serious could be addressed early on in the program. Second, we had to identify a legal mechanism for recovering costs. Many of these sites belong to companies that were dead and buried and no longer around. And so we needed to create some kind of a system that would allow the recovery of costs, because one of the other objectives was to identify who was going to be responsible. There's some fascinating dialogue in the original transcripts for CERCLA on who should be a responsible party. There's many of us argue that we got that wrong, and while we intended to make polluters pay, the statute is argued by some to have just become one of searching for deep pockets, but we'll set that aside for today. One of CERCLA's objectives was to identify responsible parties and create a legal mechanism for recovering those costs. The other thing it did was create a super fund, which you'll note in the news or in reporting at any given time in the past few decades, it's had no money in it or had some money in it. The super fund was created to cover cleanup costs in those situations where there were just no viable parties. And again, going back to the legal mechanism, allow the Environmental Protection Agency a procedure to try and recover those costs that are spent out of the super fund. And then later, there was a notification system to identify the occurrence and location of releases after certain international disasters occurred. So it's with that background that we launch into the technicalities of CERCLA and a more granular aspect to how CERCLA operates. So I think if you will advance the slides here, I believe, oh, whoops, I got one more, sorry. The numbers on the slides changed. So what causes a cause of action under CERCLA? You have to be a responsible party. There's got to be a release or threatened release of a covered substance, and there has to be an incurrence of response costs. If those elements are met, there is a cause of action under CERCLA. Now, Craig, I'm going to turn it over to you to take us from here.
Next slide, please. Thanks, Kevin. I am going to speak in a very general way to how liability works under the statute, under CERCLA. And I'll start with the fact that all of the major principles, at least to the extent that they are in the statute at all, are reflected in Section 107A, where basically Congress declares who should be the quote-unquote potentially responsible parties that should bear responsibility for these problems. And there are 4 categories of liable parties set forth in the statute. The first category pertains to current owners and current operators. So as we'll discuss, the current owner of a site is strictly liable. There are some defenses, but the government's prima facie case is actually quite easy in terms of any current owners. And the same thing is true with regard to current operators. The main operator at any site is the primary business entity that is doing business at that facility. And oftentimes, obviously, the owner and the operator will be the same entity, but in a lessee situation, the operator may be a completely different entity. And it's important to note that the current operator is liable on the same basis as the current owner. In other words, it's, as we'll see, strict liability without regard to fault. I think sometimes in the transactional context, lessees kind of aren't aware of this dynamic, and they aren't aware that they bear potential responsibility to the same extent as the owner of the property if there have been any prior activities that have given rise to contamination. The second category of liable parties in Section 107A are the owners and the operators at the time of disposal. And here again, as we'll talk about, liability is strict. So usually the owner at the time of disposal, if there is one, would have been the bad actor, if you will, the bad apple that actually caused much of the contamination, or at least contributed significantly to it. But again, here it's important to note that the owner at the time of disposal is liable as well on a strict liability basis. So again, in the ownership and operator context, liability under CERCLA is quite harsh. When I first got to Lewis and Clark to begin teaching many, many years ago, one of my colleagues, after I described the liability system to him, the very first word that came to his mind was that it was extremely punitive. It's actually not intended as punishment. It's actually only intended to identify parties who bear some responsibility. And, really the question that Congress faced in 1980 was, as between the taxpayers and these individuals, who should pay for this cleanup cost? So I think in part that rationale, the idea is, if we need to find somebody to pay for these cleanups, explains how harsh the liability can seem, how harsh the liability scheme can seem, how draconian it may seem in some circumstances. The third and last major category of PRPs under the statute of potentially responsible parties, that is, are so-called generators. The actual statutory phrase is anyone who arranged for disposal or treatment of hazardous substances at the relevant site. So usually these are the companies who sent their hazardous materials, hazardous substances is the term of art in the world of CERCLA, to the site because they were no longer useful to them. In many circumstances, at some of the largest dump sites, you can have hundreds of generator defendants. I was involved in a case at EPA when I worked for EPA that involved hundreds of generator PRPs. The site was called the Cannon site. It was in Bridgewater, Massachusetts, and actually the case involved 3 remote sites as well. But it's not at all uncommon in the CERCLA world for there to be hundreds of PRPs at a given site, most of whom in that particular circumstance are likely to be the companies that sent their waste to that site as, if you will, a final destination point. Finally, the statute does impose liability on transporters, but only in very narrow circumstances. Basically, transporters under CERCLA are only involved if they get involved in the site selection process. If I think part of my transportation business, one business advantage I am going to have is that I'm going to select sites for my customers, then I have stepped into the liability web. On the other hand, if I just do what I'm told and take the waste from company A to site B, in that circumstance, the idea is I have not done enough to trigger potential liability under the statute. Next slide, please. There are 3 overarching principles of CERCLA liability that really combine with the broad definition of liable parties to make this liability scheme particularly harsh or particularly draconian, choose your adjective. Interestingly, none of these concepts are mentioned on the face of the statute itself. Nonetheless, they are in many circumstances universally applicable, or in the context of joint and several liability, often applicable. And it's really, the case law combined with the statute that has gotten us to the point where we are. And I'm going to talk about some of those cases in just a minute. But the first overarching principle is that of strict liability. And as I'll discuss, it's kind of a special form of strict liability under CERCLA because it does not require causation. All it requires is that you are within one of the defined group of liable parties. Some people have even referred to it as status liability. If you are the current owner, for example, you are liable, period, absent a defense. So again, the government's prima facie case will be quite simple in that circumstance. The closest the statute comes to discussing this is in a definition of liability in section 101 sub 32. And all that says is that the standard of liability under this statute shall be the same standard that pertains under section 311 of the Clean Water Act. Interestingly, a dutiful law student or a dutiful young lawyer might then flip to section 311 of the Clean Water Act to see what that provision says about liability. And interestingly, curiously, it's silent. It does not directly address the standard of liability under that scheme either. But what Congress was aware of, and what Congress referenced here was the fact that the courts had universally deemed strict liability to be available under Section 311, which, by the way, is the oil spill provision of the Clean Water Act. And they trusted that the courts would connect the dots and find that strict liability applies under CERCLA. In fact, the courts have done that. One of the interesting things about CERCLA in hindsight is the extent to which legislative history has been extremely important in the evolution of this liability scheme. There are many skeptics these days about the value of legislative history. Obviously, Justice Scalia, while he was on the Supreme Court, led that fight for many years. But interestingly, in terms of establishing the basic principles of CERCLA liability, the case law is replete with references to legislative history that pertains to the relevant questions. And one of the most notable circumstances is that which I just mentioned, which is that Congress, again, made clear that by referencing Section 311, what they meant was that CERCLA should operate on principles of strict liability. We see the same thing with regard to legislative history in the joint and several liability context. The statute says nothing about this, but the courts recognized right away, as I'll discuss in just a minute, that what Congress meant under the statute was that while joint and several liability would not be mandatory, meaning that it should not be applied in each and every case, that the courts should look to what are quote unquote traditional and evolving principles of the common law and apply joint and several liability in circumstances where it would be appropriate under the common law. And then lastly, we have the idea of retroactive liability. Again, a somewhat startling proposition, but the idea is it doesn't matter whether the activities that you engaged in that might give rise to liability occurred before this statute was passed or whether they occurred after the statute was passed. Even if you contaminated a site in the 1800s or in the early 1900s, you can bear potential responsibility under CERCLA, and there have been many cases where that dynamic has come into play. And the idea is it's a remedial statute. So there's much more liberty for Congress to impose retroactive liability because we're not imposing fines. At least in theory, we're not punishing anyone. We're not saying that you did anything that was wrong or illegal. Really, the only judgment here, again, is that as between you and the taxpayers, we think it's more fair that you pay for this cleanup because you had a role in causing the problem. Next slide, please. So I want to talk for a few minutes about what I consider to be the most important liability decisions ever issued under CERCLA. And it's kind of curious because many of these were the early cases, and they were from lower courts, but they established the principles that courts have consistently applied ever since. In fact, I think the most frequently cited CERCLA case for a CERCLA liability principle ever was decided by the Second Circuit in 1985 in the Shore Realty case. And that case involved a current owner, and the court really established two propositions. The first proposition is just, yes, the current owner is strictly liable without regard to whether it contributed to the contamination in any way, shape, or fashion. And the second is that this liability happens without regard to any notion of causation. Okay, so it's a special form of strict liability. Not only does the government not have to show negligence or any type of malfeasance, but the government doesn't need to show that you played any part in causing the relevant contamination. All the government needs to show, or any CERCLA plaintiff for that matter, needs to show is that you are the current owner. And the court reached that conclusion primarily by noting that CERCLA has three, or the original version of CERCLA had three causation-related defenses. And Section 107 on its face says subject only to the defenses set forth in subsection B, the following entities shall be liable. Okay, and what the court deduced from that is that if the government had to show causation, those defenses would never come into play. So the relationship between the affirmative liability case in Section 107A And the defenses in Section 107B, the court found indicated that causation is not an element of the government's case. And as far as I'm aware, and I'm aware pretty far on this, that case, no court has ever disagreed with that analysis. Okay, and that is certainly one of the linchpins of CERCLA liability. The second case was a district court case from Pennsylvania, and it really was kind of the most thorough analysis of the elements of generator liability. And the key point here that the Wade court focused on is, does the government need to show that your waste, a particular generator's waste, are still at the site or are in the contamination? And the idea was, no, it does not. Basically, what the Wade court said, and what virtually every court since has followed, is all the government needs to show is that you sent your waste to the relevant site, that wastes of the same type are found at the site, and that there was a release of any kind of hazardous substance. Okay, and the idea in this regard, particularly on the second prong of that, is that if the government had to show that the trichloroethylene, for example, at the site, just to pick a random ubiquitous Superfund contaminant, actually came from you, it's virtually impossible to fingerprint chemicals. It was then, and it still is now, as far as I know. And so the idea was, the relevant phrase in the statute in this regard was such substances, such hazardous substances. And what the court said is, that doesn't mean yours. It means hazardous substances of the same type. Okay, and again, that's been a key principle of generator liability ever since. The third case might be the most important case of all. It's the Chemdyne case. And actually, Judge Rubin, I don't know whether he's still alive, who wrote this district court opinion back in 1983, if he's still alive, he must have been thrilled, because the Supreme Court in the Burlington Northern case, that comes a little bit farther down on the slide, actually called this the seminal decision on joint and several liability. And what this court did was to thoroughly go through the record and to trace that legislative history that I alluded to earlier, and to say that, yes, Congress intended to impose joint and several liability where it would be appropriate under the common law. Okay. Secondly, the court decided that when we reference the common law, we must mean federal common law, because we need a uniform liability scheme for multiple reasons, the court said, but most significantly, in my view, because the ability of the government to recover its costs, to replenish the Superfund, should not depend upon the vagaries of state law. And in that regard, the court looked to the Restatement Second of Torts as establishing the relevant common law that existed, at the time CERCLA was passed. And what it found was that the defendants bear the burden of establishing divisibility or any other reasonable basis for apportionment. And if the defendants can't establish apportionment, then the idea is, again, they are to be jointly and severally liable at a particular site. And then the court went on to note that, hey, in this particular site, there are lots of different chemicals from lots of different companies that have been commingled in the soils and in the groundwater. And it's going to be very hard for the defendants to make out an apportionment case. And the court specifically rejected the idea that volume alone could be a basis for apportionment, because we need to learn about many things. This court, I think, mentioned migratory potential and toxicity. But other courts have emphasized things like the possibility of synergistic reactions between the chemicals when they are commingled in soils and groundwater. So again, Chemdyne has proven to be the seminal case, so termed by the Supreme Court itself, on the issue of joint and several liability. The next case that I want to mention, Olin, is the most important case on retroactive liability. And what the 11th Circuit did in that case was it looked to a Supreme Court precedent in a case called Usury versus Turner Elkhorn, which involved the Black Lung Act. And it noted, again, that Congress has much more flexibility in the remedial context. In the Black Lung Act, what Congress was trying to do was it was trying to fund a compensatory scheme for miners that got black lung disease, black lung problems from mining activities in the prior decades. And the idea was it's okay for Congress to do that on a retroactive basis because this is remedial, it's not punitive. And again, that what the courts have universally decided, and the Olin Court decision is the leading one, is that same principles apply under CERCLA. And in the Monsanto case, what the Fourth Circuit did in that case was it decided that this is fully constitutional. Again, Usury versus Turner Elkhorn being the leading case. Because the idea is we're not imposing punishment. We are just trying to make sure that this site gets cleaned up and that the taxpayers don't have to pay for it. Okay. At the bottom of this list here, I have two Superfund decisions. Interestingly, the Supreme Court only got involved with the Superfund liability scheme fairly late in the game. Many of the relevant principles had already been established. In the Burlington Northern case, there are two very interesting ideas from the Supreme Court with two different PRPs or sets of PRPs. On the generator front, one issue in the CERCLA context is what if a company has used a material for its intended use, but the material has significant residual value or any residual value for anyone else, and is transferred, and then contamination ensues. And the question is, should that be deemed to be an arrangement for disposal? And there had been several cases that had said so. One of my favorites is a district court case from New York involving General Electric, where they sent PCB, contaminated waste oil, to a drag strip. And the Second Circuit said the district court in New York said the fact that you got paid a few dollars is not going to prevent us from seeing this transaction for what it really was, an attempt by you to get rid of something. In Burlington Northern, the court basically said that is the key principle. The phrase is arrange for disposal. So Shell in that case was selling chemicals, and some of the chemicals were spilled in the delivery process. Shell knew this was happening, but what the Supreme Court said was Shell did not intend for it to happen. That's not what it desired. In fact, it would have preferred, obviously, that there not be any spillage, and because it had to give a discount basically to this particular customer because it recognized that there was spillage in the delivery process. And Justice Stevens, writing the Supreme Court's opinion, said the key is the verb arrange requires some kind of intent that there be disposal. It's not just that you knew it was happening. It's not just that you knew it might happen, excuse me. Interestingly, on the one hand, it was a case where the court found that there was not liability. But on the other hand, it articulated really the key principle going forward with regard to arrangements for disposal. And again, that is, if you have a secondary material and you are trying to get rid of it, the fact that you may get paid a few dollars is not going to negate potential Superfund liability. And basically, that's how the case law has borne out since. Okay. The second aspect of Burlington Northern was on the joint and several liability prong. And here we had some railroads that owned a portion of the site. And interestingly, the district court in that particular case apportioned liability sua sponte, primarily based on the percentage of the site that the railroads owned and the overall time period that the railroads owned the site as compared to the time period over which the chemical handling problems were happening. And the Supreme Court reversed the Ninth Circuit and said that was a reasonable apportionment and should be upheld. But frankly, that has not proven to be the most important part of the decision on joint and several liability. If you look at the case law since, it's been 15 years since Burlington Northern was decided. Really, there has been almost zero change in the law of joint and several liability as a result of this case. What the lower courts have seized on is the fact that the Supreme Court seized on the Chemdyne approach as being the correct approach to liability. And in the vast majority of cases, since Burlington Northern was decided, the lower courts have deemed joint and several liability to still be appropriate under the statute because the defendants have failed to identify legitimate bases for apportionment, especially in circumstances where you have commingled waste from various different waste streams that are commingled in soils and groundwater. Like some courts have called that a chemical soup situation. So if you have, again, many chemicals that have been commingled, the idea is how can we possibly know whose waste is causing what portion of the harm. The last case that I'll mention is Best Foods. And Best Foods deals with operator liability, but interestingly, it deals with the circumstances under which secondary entities, other than the primary operator of a site, can be deemed to be an operator. And basically what the Supreme Court said, this was in the context of a parent corporation, is that a parent corporation will only be liable as an operator itself if it gets impermissibly involved in operations at the relevant facility. If a representative of the parent corporation comes down to the subsidiary site and starts directing it as to how to resolve particular environmental issues, that is a basis for liability. But two parts of that. One, the court said it has to be environmental decisions. Being involved just in ordinary operational decisions is not enough, given CERCLA's focus. And secondly, that it has to be directive behavior. Okay, and so that those are very important principles in many circumstances. Obviously, CERCLA plaintiffs would like to be able to impose liability, operator liability on people who tangentially were involved in causing the contamination or in running certain sites. But Best Foods really has established basically the general dynamics in that context. Thank you.
Thanks, Fred.
Thank you, Professor Johnson. We appreciate that. Martha is going to talk to us a little bit about the practicalities of CERCLA and how it works.
Thanks, Kevin, and thanks, Craig. As Kevin said, I'm going to talk a little bit about the day-to-day of CERCLA cleanups and litigation from a practitioner perspective. I'll pick up though where Craig just left off and note that the Best Foods decision that he was mentioning has like 2 to 3 key sentences in it about what it means to be an operator of a Superfund site. As he said, a secondary operator where you're not the primary operator. And over the past 12 years, I've probably written dozens, if not hundreds of pages across different briefs and cases about what those 2 to 3 sentences mean in practice and how they apply to different situations, which is pretty standard for CERCLA because CERCLA is a really interesting environmental statute as far as environmental statutes go, because it's somewhat less detailed than some of the others. The Clean Air Act, for instance, is somewhat more detailed. There are regulations that accompany CERCLA that were promulgated by EPA. Those regulations are called the National Contingency Plan, or NCP, and those do expand and provide somewhat more detail on what cleanup should look like. But again, they don't cover every situation, and they don't really go at all to allocation of cleanup costs, which is one of the things I'm going to talk about. They go more to how to conduct cleanups under CERCLA, and again, less about allocating costs between responsible parties. So as a result, CERCLA is on the one hand very broad and can be pertinent to a large variety of situations and fact patterns. But different agencies, regions, companies, and courts can take a range of interpretations and approaches. And it also means, and Craig talked about several examples of this a moment ago, that courts have had a large role in shaping CERCLA because there's not always clear direction in the statutory or the regulatory text. So going to on the ground, what does a CERCLA cleanup and litigation look like? The quintessential example of a CERCLA case and cleanup is where EPA designates a site as a Superfund site and then pursues one or more private parties for cleanup of a historically contaminated site. EPA has a variety of mechanisms by which it can pursue parties in the first instance. It can issue what's called a unilateral administrative order. It can enter into administrative or judicial settlements with parties it's looking to pursue for cleanup, or it can go ahead and sue and seek cleanup and cleanup costs that way. Because liability is joint and several, as Craig said, EPA only needs to pursue one party. If there are other responsible parties, whether it be 2 or 3 or hundreds, it can be up to the initial party to bring them in through litigation or otherwise to allocate responsibility and share the costs. And that joint and several liability is one of the key tools that CERCLA supplies agencies to address the goals of CERCLA to address past contamination. So EPA doesn't have to spend the time at the front end to go out and find every single responsible party. And Craig said this, I think, a few times, but generally speaking, establishing liability can be fairly straightforward. But once you bring in more parties, and I'll circle back to this in a moment, once you've cleared that initial liability threshold, you do get into issues of causation and culpability when you're assessing what cost shares each party should bear. And that's part of a process that's usually referred to as equitable allocation, where the courts have significant discretion to assign different cost shares to different parties. So I talked about sort of the quintessential fact pattern, but there's a large variety of fact patterns under CERCLA. For instance, a state can direct a company to do a cleanup under state law or under CERCLA. Even if it's truly a state cleanup, depending on the jurisdiction, a company can still potentially sue other responsible parties for cleanup costs under CERCLA. I'll add that even if it's an EPA lead site, the state is usually consulted and involved too, and that's a really important part of the process as well. And generally speaking, you can have sites that vary significantly in terms of size, contamination, number of parties, history. So when you're dealing with a cleanup site, especially if you're thinking about bringing in other parties or thinking that you might be linked to a site, it's really important to assess what type of site it is, both historically, but also procedurally. So one initial consideration is it a small upland site? So this could be like a historical manufacture or disposal site where someone produced something and released hazardous substances years or decades or sometimes even centuries ago. Alternatively, the EPA regulations actually allow EPA to define Superfund sites by the aerial extent of the contamination. And what that means, especially in heavily industrial areas, by urban waterways, is EPA has the ability to designate really enormous mega sites where you can have, for instance, miles and miles of river that are a single Superfund site. And you end up pulling in dozens, if not hundreds, of parties that each operate their own facility in and around that water body, and they're all part of one massive Superfund site. The smaller sites, can cost millions to clean up, but the largest of the mega sites are generally projected to cost billions. A second consideration, which is very related, is the number of parties that might be involved. Smaller sites can have just one responsible party, or maybe two or three if you had multiple sequential owners that sold the site over time. As Craig said, both current and past owners and operators are liable. So a current owner who's conducting cleanup could bring in a former owner that might have caused some or all of the underlying contamination. But again, you get to large mega sites and you can have dozens, if not hundreds of PRPs, which makes figuring out the appropriate shares of cleanup costs much more complicated. It can also, depending on the circumstances, also making cleanup decisions more complicated because it sometimes means you end up with more voices in the room. A third consideration, and I sort of touched on this earlier, is who's leading at the site. It's frequently EPA or a state, but sometimes parties do voluntarily take on cleanup themselves. And if they do it with sort of sufficient agency and or public input, and if they do it in a manner that's consistent with EPA's regulations, at least in some jurisdictions, they might still have a CERCLA action that they can bring against other responsible parties to recover some cleanup costs. And that's related to a fourth consideration that I didn't actually put up here, but is really important and relates to some of what Craig said, which is that the Supreme Court takes CERCLA cases fairly rarely. It's taken a few. I think the last one was US v. Guam. But CERCLA is a fairly high-level statute in a lot of ways, and there's a lot of room for different interpretations. And so as a result, even today, decades after CERCLA has been enacted, there are still a lot of splits in the district courts and the circuit court levels about some fundamental issues. And some examples are what compliance with the National Contingency Plan means. And that's important because if you're looking to recover costs against a private party under CERCLA, you have to show that you were consistent with the National Contingency Plan. Another split is what type of claims private parties in particular, can bring in different circumstances. CERCLA generally authorizes folks to bring two types of claims. One is called a cost recovery claim under CERCLA Section 107. And if a private party has the ability to bring a CERCLA Section 107 cost recovery claim, they can actually themselves seek joint and several liability in the first instance. On the other hand, there's another type of claim under CERCLA called a Section 113 contribution claim, where recovery is limited to the defendant's fair share of cleanup costs. And in practice, there's not always a distinction between the two, because you can always file a contribution counterclaim. But nevertheless, courts split on what circumstances you're supposed to bring a 107 claim and what circumstances you're supposed to bring a 113 claim. And as a result, a lot of parties sometimes bring both in the alternative. A third key area of dispute is when the statute of limitations starts in different circumstances. That's also been the subject of different interpretations. And at a practical level, it means sometimes parties file suits sooner rather than later because they're not sure when the statute of limitations will end. So knowing the law of the jurisdiction that you're in is really important, especially if a company is seeking costs from other parties or defending against such a suit. Next slide, please. So if you do end up in a dispute with multiple parties that are trying to figure out who should contribute what cost to clean up, here are some other considerations that inform the strength of a case. These are actually just a couple of examples. There are many more, but for purposes today, I wanted to give a couple. Some go to liability in the first instance, but also ultimately to allocation and equitable shares. Again, once you've cleared that liability threshold, and you know parties are going to be liable for something, the question then becomes how much is each party responsible for, and that's based on the court's, if you're in court, on the court's equitable determination. So one consideration is, what type of nexus to the site does each party have? As Craig said, if you're the current owner or operator, liability is almost automatic. If you're a former owner or operator, then you also need to show that a company was there at the time of the release of a hazardous substance, but that's still usually not a high bar for liability purposes. On the other hand, if the alleged nexus is generator or arranger liability, that can be a slightly higher bar. And it's another place where I think, as Craig said, different circuits have come up with different standards, although you generally need to show that a party's hazardous substances actually ended up at that site that's being cleaned up, and that there was some intent for hazardous substances to be disposed of. Another important consideration is, when did the contaminating activities occur? It happens all the time that the site activities could have really ceased decades ago, which means you're not likely to have any witnesses to the operations. You might have witnesses to the cleanup, but when it comes to figuring out who did what and when, you're really going to be relying on documents and expert witnesses rather than fact witness testimony. One of the first cases I worked on as a junior associate involved contamination related to aviation gasoline produced to support the World War II effort back in the 1940s. Which meant that part of my job as a first-year associate was digging through old US archive materials about World War II production and waste, which was not at all what I was expecting to do, but ended up being really interesting. So the age of activities can impact what type of evidence you have. Interestingly, though, it doesn't actually impact when the statute of limitations runs. I said that there's some disagreement in the courts about when the statute runs in particular circumstances, but I think what everyone agrees on is it doesn't run from anything having to do with when the contaminating activities actually occurred. It generally runs from certain dates related to when the cleanup occurs. So if the cleanup occurs decades after the contaminating activities, the statute of limitations can run, again, decades after a party might have disposed of something at a given site. And that's how we end up litigating, again, decades later, about things that happened in the 1950s or 60s or even considerably earlier. And just circling back to liability quickly, I talked through some of the liability considerations, but I do want to note that Kevin's going to talk about defenses to liability in a moment. So even once you've established liability in the first instance, there are some defenses that might negate liability that are worth working through, but I will leave those to Kevin. Next slide, please. So I put up this slide in part to illustrate that there are frequently two tracks of activities happening at CERCLA sites and in CERCLA cases. On the one hand, there's the investigation and cleanup track, where the work is actually getting done to clean up the site. And then on the other hand, there's the resolution of who is paying what track. Usually investigation has at least started before companies or responsible parties start fighting over how to allocate the costs. Sometimes both tracks can happen simultaneously. Sometimes a party or an agency will finish the cleanup and it will be done before any disputes about allocation and cost are started. But again, because CERCLA liability is joint and several, and EPA or states have the ability to pursue a single party or a small subset of parties to conduct cleanup, the allocation track usually doesn't delay the cleanup track significantly. You can be working on them at the same time. On the cleanup side, I'll just flag a couple of high-level decisions that agencies and PRPs sometimes work through. There are actually two types of response actions that you can take under CERCLA. One is called a remedial action, and that's usually a more site-wide comprehensive cleanup that have numerous steps on the investigation and design and cleanup side. And I'll show a diagram of that on the next slide in a moment. But agencies and PRPs can also conduct something called a removal action, which is a more short-term cleanup, sometimes a time-sensitive cleanup to address an area of particular concern. And it can be more streamlined if you're trying to take an early action. On the allocation side, I'll just note that parties can work through disputes about who is paying what in a variety of settings. EPA or states usually pursue parties in the first instance that I think the agencies think are both viable and more responsible for the cleanup, for the underlying contamination based on information in front of the agency at that time. That information can evolve. But again, the initial parties can bring in other parties and they can try to work things out through just informal settlement negotiations. On one hand, parties can sue each other and go to federal district court on the other hand, or in the middle, and parties do this with some frequency, they can bring in an allocator or a mediator to help the companies work to a resolution without going to court. Next slide, please. So just a couple more slides and then I have a diagram of what some of this can look like in practice. But this is a diagram from EPA. It's actually, I think, a couple decades old now, but still fundamentally correct. But this is basically all the steps that a CERCLA remedial action can take for reference. And it starts with investigation and it moves on to assessment of different potential remedies, and EPA will then, or the PRPs or the state will propose a plan for public comment. And then ultimately there will be a record of decision selecting the remedy. And the record of decision is that rod in the purple that you can see in the middle, which indicates you're about halfway done. Because then you end up doing the design and the cleanup and future 5-year reviews of the site to make sure that the cleanup was effective. So at smaller sites, this process can take years. At larger sites, it really truly can take decades. So I'm not going to go through each step, but just wanted to highlight how many steps there are in the CERCLA cleanup process. Next slide, please. So switching gears back to the allocation side of things, courts have very broad discretion with how they want to allocate costs. Once the courts have determined that the parties are liable, it's generally the court's discretion to decide what equitable factors they want to consider. There are two common lists that courts cite to, and I'm not going to go through each one, but two common lists of equitable factors that courts will usually at least cite to and decide if they're going to use or not. They're not exclusive lists. Courts think about other things all the time, but one of the main lists is called the Gore factors. One is called the Torres factors. At a high level, the two lists include things like considerations of degree of care used to handle waste, level of cooperation, ability to show who disposed what, culpability, etc. One of the factors that's frequently cited that's not on either list is knowledge of contaminating activities, and that can come into play if you have owners who are leasing property or people who are leasing property who do or don't know what has happened or is going on at the site. Benefit from disposal related activities is another one that can come up. But again, not exclusive. Courts don't have to consider all of them. Courts can come up with their own factors. And what that means is there's a lot of room for not just courts to exercise their discretion in deciding how to allocate costs, but there's a lot of room for different companies to make different arguments about how costs should be allocated. Next slide, please. Okay, so last points from me on CERCLA. This is a really high level diagram of what you can see at a given Superfund site and how you can have cleanup and allocation tracks operate in parallel. Basically, you can have EPA pursue, and just as an example, I'm using one party. And again, just as an example, I'm saying here that they issued Party A unilateral administrative order telling them to start working on investigation and cleanup. So Party A and EPA will start working on the investigation and cleanup, and Party A will be paying costs in the first instance. At the same time, or perhaps a little later, Party A can file a lawsuit against parties B and C under CERCLA to push them to contribute something to the cleanup costs. Depending on jurisdiction, Party A might bring a 107 cost recovery claim or a Section 113 contribution claim, or both, because this is one area where the courts are definitely split. If you get issued a unilateral administrative order, what type of claim do you have? Courts have gone different ways on that. In any event, while the investigation and cleanup is proceeding, the parties are litigating amongst themselves over liability and allocation. And if the court ultimately says, for instance, that Party A is responsible for 50% of the costs and parties B and C are responsible for 25% each, then parties B and C would pay their share of Party A's past costs, and the three parties would generally split costs going forward, because the court would likely enter a declaratory judgment action saying that those two parties are responsible for 25% each of costs going forward. This is a really simplified summary. Party A is sometimes parties A to F, and parties B and C can be parties 1 to 100. And instead of one UAO, there might be 3 and 2 other settlements and 1 prior litigation, and insurers lurking in the background, and potentially multiple agencies working on this. So there are always a lot of moving pieces on CERCLA cleanups and litigation. But wanted to show just a very simplified diagram of what it can look like in practice. And with that, I think I'm turning it back over to Kevin to talk about defenses.
Okay, thank you. Before we go to defenses, I'm going to make an executive decision for both you, Craig and Martha. We've got a lot of questions, but most of them are focusing on the same issue. So I think it might make sense to just kind of clarify this at this point. One of these is directed specifically to you, Craig, and Martha, feel free to chime in on this too. We're getting a lot of questions asking if we can give a little bit more definition to what it means to be an operator on a site. And specifically, what happens if we have somebody who's not an owner, but truly an operator, like a utility company that comes on site to do pipeline or utility work. And my favorite question, Craig, directed specifically to you is, can the federal government as a landowner be a PRP?
Let me start with that last one first. The federal government clearly can be a PRP. The definition of person under the statute includes all governmental entities. And the government has been treated as a PRP at numerous sites. However, in many contexts, the government will have a defense as a landowner, especially if some vandal or some other ne'er-do-well comes onto federal land. This happens frequently in the national forests, unfortunately, and dumps a lot of hazardous substances. And the idea there's a third-party defense under the statute, and what it requires is that a third party was the sole cause of the release. That there be no contractual relationship between the person asserting the defense and the person that caused the release, and that the government and that the relevant defendant exercised due care once it became aware of the existence of the contamination. So in many, many circumstances, the government will have nothing to worry about if it's just a landowner that was the victim of dumping by an unrelated third-party entity. On the other hand, if the government leases property to a private entity, and that private entity causes a contamination on the federal land, in my view, at least, the government would be an owner just like anyone else.
I'll just add that when I said earlier, I'd spent a lot of time litigating over what those sentences in Best Food meant when it came to operator liability. A lot of that was actually about when can a governmental agency be held liable as sort of a secondary operator of a site where it has an active role but isn't isn't actually itself the primary company that owns and operates a site. But short answer is yes. Courts have, as Craig said, courts have found governmental agencies in the U.S. government liable as both an owner and an operator under CERCLA under certain circumstances.
And with regard to contractors, as Martha mentioned, the key language in Best Foods is, were they involved in a directive way in environmental decision making? I think if a contractor comes on to the property and is just putting in a pipeline and has no idea the property is contaminated, and disturbs some soils and is engaged in routine contractor type work, that entity would have no concerns about being deemed to be an operator under the statute, because it would not have been involved in any environmental decision making.
Okay, let me tackle the defenses section. I'm going to go pretty fast because of time associated with where we are on the timing, and maybe pick some of this up at the end. I have bucketed this and tried to make it easy. If we actually go through the history of CERCLA, some of these defenses have come in at various points in time as the statute's been modified, has been modified. But generally speaking, there are three categories of defenses, and I have lumped the third one together. There are actually more defenses built into that, but generally speaking, when we talk about CERCLA defenses, we talk about an act of God, an act of war, or as Craig just mentioned, an act or omission of a third party. I have lumped some other defenses that are now available under CERCLA into the third party defense because they functionally are developed out of the third party defense if you get into it and look at the statutory language, and that's the bona fide prospective purchaser, continuous property owner, and the innocent landowner decision. Can you go to the next slide, Sarah, please? Craig just gave a great definition or great discussion on the third-party defense. I don't know that we need to spend a lot of time here. Basically, what you're looking for the third-party defense is an act or omission of a third party, not an employee or agent. The example of the third-party dumping is the best example of the third-party defense and its effectiveness as a defense itself. The problem or the deficiency in the third-party defense, at least from a transactional perspective, is that originally when the third-party defense was added to CERCLA, it contained the language that there had to be no direct or indirect contractual relationship with the defendant. You had to have exercised due care and took precautions against foreseeable acts or omissions of such third party. And in a transactional or real estate context, the defense generally fell because the statute, as we'll see in the next slide, defines a direct or indirect contractual relationship simply as a land contract or deed. So in a situation where you are acquiring property in some kind of a real estate transaction, the third-party defense was originally not available. So the defense was somewhat limited to situations that we've kind of described already. You want to go to the next slide? Contractual relationship, because of this limitation, the first attempt to amend the statute added what was known as the innocent landowner defense, which provided that if you acquired the property after disposal or replacement of the hazardous substance, and at the time you acquired you did not know or had reason to know of the contamination, or if you were a government entity and you were getting it through eminent domain, or if you acquired the property through inheritance or bequest, you could claim an innocent landowner defense. Again, this was an attempt to try and move real estate transactions in the late 80s or early 90s. It did help, but you will note the first bullet. You have to, after the hazardous substance acquired, that you had to know, or if you had any kind of knowledge regarding a historical or existing environmental problem, you could not claim the innocent landowner defense because you were an innocent. You went into the deal with information, understanding that there was an environmental issue on the property. So the first question then is, how do I know or have reason to know? Well, the statute did define it in the first attempt to amend and add the innocent landowner defense. If you want to go to the next slide, a defendant must have taken all appropriate inquiry into the previous ownership and uses of the property consistent with good commercial or customary practice. This is known as the All Appropriate Inquiry Standard. It's sometimes referred to as AAI, and it's developed. It has developed over the last couple of decades into a very formal and established relationship. When it was initially added to the Act, however, the All Appropriate Inquiry Standard, as Martha has already mentioned, which is consistent with CERCLA, did not give us a great deal of definition of what that should mean. What was appropriate inquiry and what should we do? Well, I'm just going to jump to the end and kind of come to where we are. All appropriate inquiry now means that we need to investigate the history of the property. After a number of different starts through the 90s and early part of 2000, it was finally established that in order to meet all appropriate inquiry, you had to complete what's known as an ASTM environmental review of the property, or the ASTM equivalent. ASTM is an independent national organization that identifies certain standards with regard to safety in a number of different arenas, including the environmental arena, and they have developed a protocol for an environmental evaluation that if a party completes it, then they will be determined to have conducted all appropriate inquiry into the property. Now, remember, though, as I just said, if you do all appropriate inquiry and you find something, you can't be an innocent purchaser with regard to that. It still meant that real estate deals happened. It just meant that you took the property subject to a knowledge that there was an existing environmental liability that would need to be taken care of. So the Act was amended one more time, if you could go to the next slide, to add another defense called the prospective purchaser defense. If you acquired the property after January 11th, 2002, you do not impede the performance of a response action or national resource restoration project, and you meet the threshold criteria, you can have a defense of a prospective purchaser against liability on the property, even with knowledge that there's an existing condition on the property. And this is a technical liability protection. In actual practice, what you'll find in a transactional setting is, even if though you're a BFPP, you're a bona fide prospective purchaser, taking property with knowledge of an existing contamination may still carry with it certain obligations or certain responsibilities in order to have a viable project. But under CERCLA itself, you have a defense as a prospective purchaser if you have completed these activities. Next slide. There is also a defense known as the contiguous property owner defense. This was added to the Act to solve the problem of passive migration. We have a couple of questions asking us what happens if property A is contaminated and the contamination moves on to property B or C. Is property B or C responsible for that? The original, when the Act was originally passed, there were a number of court decisions that held that the active migration of contamination under property B and C was effectively a CERCLA release and you were a liable party. So the Act was amended a couple of times to try and add some defenses to help in that situation. The one that is currently in the Act today is the contiguous property owner defense. Next slide. I'm just going to jump to a slide. You'll find this on the EPA website under common elements and other requirements. These are the three transactional defenses that are available in a situation where someone is looking to acquire and or own property that may have an environmental problem. The bona fide prospective purchaser defense, the contiguous property owner defense, and the innocent landowner defense, which are all still in the statute. The fundamental difference is in this first column. Under a BFPP defense, you can acquire the property with knowledge of contamination and have a liability shield from CERCLA joint and several liability claims. Contiguous property owner, you cannot acquire with knowledge of contamination, and the innocent landowner you cannot acquire with knowledge of contamination. Those two defenses are contingent upon all appropriate inquiry and a determination that there are no issues. So under all three defenses, as you will go down on the slide, the threshold criteria, the first element of all three defenses is that you perform all appropriate inquiry. Another element of the statute is that you cannot have any affiliation with the existing property owner or operator. That no affiliation demonstration is required to be a BFPP and contiguous property owner defense. It is not an element or requirement of innocent landowner, but remember, innocent landowner is built on the third-party defense. You have to demonstrate that it was an unrelated third party that caused the contamination. So affiliation is basically built into the innocent landowner defense section. I'm noting this specifically, and I'm not going to go through all of this list. The no affiliation is important because a lot of people miss this. If I have a company that creates a special purpose entity and that special purpose entity tries to qualify as a BFPP, it cannot do so if it's affiliated with the parent. Now that's subject to best foods analysis, but you need to be careful with the affiliation. Functionally, the reason the affiliation requirement was added was to prevent a situation where owner A can try and forego or eliminate environmental liability by selling the property to company B, of which it is a controlling entity. That affiliation requirement ends up being a limitation on what can be applied there. You'll note as you walk down the threshold criteria, there's a number of things. No affiliation, you have to acquire it after January 11th. That's only a BFPP requirement. Next slide, if you would, please. There are a number of other obligations that have to be met and or continue to be met once the acquisition occurs. You have to take, for example, reasonable steps to manage releases. That's required under all three actions. So even if I have a defense as a BFPP for existing contamination, I'm going to be responsible to take reasonable steps to manage releases from that particular facility. If I fail to take reasonable steps, then the defense is lost. So there are additional steps and measures that have to be taken after you move forward on a transaction. And this becomes kind of, this is really where the tires meet the road, so to speak, is that you make sure that you complete your reasonable steps, you cooperate with the agencies, you provide necessary access, give any notices that you may have to give. And we don't have time to really sit in the middle of this chart, but I will make the reference to, this is on the EPA website, for those of you who are engaged in or plan to work in an area where we're worried about transactional liability that's created from acquisitions, mergers, stock purchases. That's probably a bad one to raise. But if you're involved in acquiring real estate and going to step into the ownership responsibility that Professor Johnson mentioned at the beginning of this lecture, if you're going to step into that ownership situation or scenario, you want to make sure that you've taken whatever steps you can take to qualify as a BFPP or an innocent landowner to the extent possible, so that you don't find yourself sitting in that ownership liability or operator liability area. Let me note that as Professor Johnson mentioned, operator liability is somewhat consistent with the concept of being a lessee. A lessee on a facility often creates operator liability, even though you're not an owner. So in many circumstances, we have clients who still want to qualify as a BFPP, even though they're going to be a lessee. There is some case law to suggest that if your owner is a BFPP, there is a derivative protection that transfers to a lessee, but that's a little bit risky. And finally, if you go to the next slide, the one other thing, go to the next one. I've already mentioned those. Lender liability is another one that I just want to mention in passing. In the late 90s or late 80s, early 90s, if the word environmental entered any kind of a transaction, it sent fear through most lenders. There were a series of cases, Mirabel case and a number of others, that found situations where lenders were liable. I believe Fleet Factors might even have been in there. There were a series of cases that suggested that if lenders had the ability to exercise control over management decisions, whether they exercised it or not, that they could incur CERCLA liability. It caused a situation where lending on property deals became very difficult. What happened in this particular scenario to resolve this liability is that EPA promulgated regulations in 1992 that were struck down, but then added as part of the original act in 1996. The importance of the discussion we're having here is that there are built-in lender liability protections in the statute. It is important in a transactional context because a lender does not have to try and qualify for BFPP or as an innocent landowner because they have their own statutory protection that's built into the act itself. The real key to it is that a lender must be taking actions to protect a security interest, and they must continue to act as a lender. You can, as a lender, step into a situation, foreclose, and operate a office building or some kind of a commercial facility as a reasonable owner, as long as you're taking measures to market the property is the easiest way for me to see it. If a lender's acting as a lender, the lender liability protection will apply. If a lender forecloses on property and then tries to take it as a full-blown asset or real estate asset, that becomes a significant asset for the institution. My belief is that the lender liability exemption will fail. And then one last one. Let's do one last one. The act of God and act of war. I used to skip over these. Sarah, can you go one more? But this has become much more of an issue in recent years. It used to be that if there was a natural disaster or some unforeseeable event happened, that the defense of an act of God was available under CERCLA as a fairly evident and clear course of action as a defense. We are seeing a very interesting scenario happen in the last probably decade, certainly the last 5 years. And the notion has been that natural disasters are becoming more and more common. And the question has arisen, and the early litigation has been, it was really not an act of God. You should have known that there were going to be that kind of a natural disaster. We've seen, I'm making this up, but the data would suggest that hurricanes have become much more prevalent in certain areas of the country, and it is reasonable to expect that they are going to occur, and therefore you need to take reasonable precautions to prevent environmental releases from occurring in the event that a natural disaster hits, if you will. The early cases, plaintiffs are having a hard time with this theory, but we're seeing it being brought more and more. Houston, there have been several cases that have been quite that have been in the press and covered quite heavily. It's going to be an area that I think we're going to see activity in the near future. The question is simply going to be whether that natural disaster was an act of God or a foreseeable event. And if a plaintiff can prevail that it was a foreseeable event, then the owner or operator of the property will be found to have needed to take precautions to prevent foreseeable releases. I think that wraps up the CERCLA section. Is there anything, Craig or Martha, you want to add before we move on?
Not for me.
Not for me, thanks.
Okay. We'll move into the RCRA section then. As I mentioned on the beginning of the slide, RCRA regulates hazardous waste, as opposed to the conversation that we've been having where CERCLA represents hazardous substances. And oftentimes in a CERCLA context, we're trying to find potentially responsible parties because it's historic and it could have been decades ago that this particular act happened. I don't want to get into a series of war stories, although it would be very fun. But Martha triggered one of my early Superfund sites occurred in South Carolina because they went out to start work on a shopping center and turned over 40mm NA aircraft shells. Turned out to have been a historic facility where they manufactured those during the war. That's your common CERCLA scenario. RCRA is different. RCRA regulates waste from the cradle to the grave and has several subtitles that focus on regulation of waste material, which we're going to talk about now. With one exception, I call it the add-on. RCRA is where we find regulations related to underground storage tanks because petroleum is not a hazardous substance under CERCLA. So when you have a petroleum scenario, all the conversation we just had with regard to CERCLA liability is generally not applicable, and we've got to look to RCRA to see whether or not there's a RCRA issue related to a petroleum release. With that, Craig, do you want to kick us off?
Sure. Next slide, please. So I am just going to do a very, very quick overview of subtitle C of RCRA, which is the hazardous waste portion of RCRA, which is what most people think of when they first think of the statute, even though it does have a solid waste program. And as Kevin just mentioned, a program dealing with underground storage tanks. But in the hazardous waste context, what we regulate the generation of hazardous waste, the transportation of hazardous waste, and also the treatment, storage, and disposal of hazardous waste. Next slide, please. Sorry, next slide, please. The first question is, do we even have a solid waste? And this is actually the most difficult issue by far in the entire program. There have been decades of litigation, decades of EPA attempts to come up with a thorough and satisfactory definition. And the real question is, under what circumstances can a material that is destined for some kind of recycling or reuse still be deemed to be a solid waste, or in the vernacular, still be deemed to be a waste? Those solid waste and the term waste are used interchangeably pretty much in the RCRA context because a solid waste is defined to include liquids and contain gases. So basically, the question comes down to can this material fairly be deemed to be waste material? Again, this is a very complicated question, years and years of efforts. I'll come back to it in just a minute. The second question, though, is if it is a waste, is it also hazardous? And the key point here really is that the universe of hazardous waste is a subset of the universe of solid waste. If a material is not a solid waste within the meaning of RCRA, then it can't possibly be regulated under subtitle C, no matter how hazardous it is. So if I have a drum of pure TCE, 1 million parts per million, very, very, very toxic stuff. If that is still product, if it hasn't been used for anything at all yet, RCRA just simply will not apply. Subtitle C simply will not apply. Next slide. In terms of determining whether a secondary material is a waste, again, one of the key points here is that it has to be a secondary material. The material has to have been through its primary intended use before any of these issues arise. But the hardest part of this undertaking is drawing the line between what is legitimate reuse or legitimate recycling and what is so-called sham recycling. When is somebody trying to recycle something mainly as a way of avoiding the cost that would otherwise attend to dealing with waste materials, okay? And we've had a series of rules over the years. Some of the main ones are EPA's old rules in 1985. The Obama administration promulgated a set of rules in 2005. There was a big DC Circuit opinion in the American Petroleum Institute case, and the Trump administration responded to that in 2018. But honestly, the answer right now is somewhat chaotic. You can go on EPA's website and easily find a chart of which rules apply where. But one of the key dynamics that makes this so chaotic, although frankly I support this idea 100%, is that states are allowed to have programs that are more stringent than EPA's current program if they so choose. There is no preemption here with regard to the stringency or the breadth of state hazardous waste regulation. And so, EPA's old rules really were the broadest rules to date. EPA was very cautious in the mid-'80s about letting materials escape the subtitle C net when they were going to be potentially recycled or reused in ways that EPA found to be problematic. So many states, including California, I believe, New York and Massachusetts, and some of the most liberal states, have simply clung to the old rules. They haven't made any changes yet to to address either the Obama rules. There was actually the George W. Bush administration had a set of rules as well that I omitted because it's largely outdated at this point, or to take into account the American Petroleum Institute case and the rules the Trump administration promulgated in response thereto. Okay, so again, if you're representing a company and they have operations in several states, I haven't done this in a long time, so I really probably should leave this to the experts. But it can be somewhat disconcerting for the client to learn that what is considered to be a waste and therefore potentially subject to Subtitle C can vary significantly from state to state. Okay, but that's where we are right now. Next slide, please. Okay, in terms of determining which wastes are hazardous, EPA long ago created two mechanisms. One is there's a set of wastes that are just, if they are waste, they are hazardous by definition. These are so-called listed wastes. But secondly, EPA has established a mechanism for basically a kind of a catch-all dynamic for capturing other waste materials in the Subtitle C net if they pose identified environmental concerns. So on the listed waste context, sometimes it's just chemical specific. Those are the U series waste and the P series waste. Don't ask me what the U stands for. I have no idea, or the K or the F. But some are the result of particular processes. The K series wastes are only generated by specific industries, and their waste streams are identified as being hazardous waste per se because of the concerns they pose. For example, non-spec pesticides. If a pesticide manufacturer generates some pesticides that don't meet its standards, and so it's not going to sell them, the idea is that, and it becomes waste material, it's by definition hazardous waste. Okay, F-series wastes are not industry specific, but rather they are process specific. So, many different companies may use a similar electroplating process in many different industries. And in many circumstances, the waste stream, the sludge from that electroplating process will be deemed to be hazardous waste per se, under, again, the F-series characterization. With the characteristic waste, there are four different concerns that EPA has identified: ignitability, corrosivity, reactivity, and toxicity. By far the most important of them in terms of the numbers of materials that are captured and have to be regulated as hazardous waste because of these concerns is the toxicity test. Next slide, please. EPA long ago invented a test called the Toxicity Characteristic Leachate Procedure Test, or the TCLP in acronym speak. And the animating concern here is that, if this material were to go to an under-regulated Subtitle D landfill, how much of a risk would it pose? Might the contaminants leach into the groundwater? If so, at what levels? Might that groundwater migrate to a nearby drinking water well? If so, at what levels? And generally speaking, the idea is you have to run it through this leachate procedure that is supposed to mimic kind of reasonable worst case scenarios for landfills. And the idea is, at what level do the toxic materials migrate into the groundwater? And we're going to allow for what's called dilution and attenuation that may occur between the point where the wastes enter the groundwater and then the point at which there may be drinking water wells down gradient. And generally, EPA uses 2 orders of magnitude, 100 times as the multiplier for a dilution and attenuation factor. So generally the TCLP numbers are set at 100 times drinking water standards for the relevant contaminant. So the idea is, if you have any doubt about whether your waste may be toxic under this test, you have to run it through the TCLP. You don't need to test every batch. If you get consistent results, you can certify that it's not toxic based on your knowledge of the waste stream, or perhaps treat it as toxic based on your knowledge of the waste stream just routinely. But again, that's how the TCLP test works. Next slide, please. There are 3 expansive principles that apply only to listed wastes. And this, significantly makes the program harsher for those who generate listed waste. One is the mixture rule. The idea is, if you mix your listed waste with any other waste stream, the resulting mixture is by definition a hazardous waste, so long as we can find any of the constituents that cause the original listed waste to be listed in the first place. Okay. The second is the derived from rule. The idea here is that if you have treated your hazardous waste in any way, shape, or fashion, partially treated it, if the resulting stream after treatment that is still a waste, if it still contains, if we can find any of the constituents, again, for which the waste was listed, that material is still deemed to be hazardous waste. And then finally, there's the contained in policy. And the idea here is if you spill listed waste on the ground or into the soils or on the floor, and you clean it up, the mop, the dirt, everything that comes into contact with the listed waste that you spilled is by definition still considered to be hazardous waste. Again, if we can still find any of the constituents that were of concern that caused EPA to list the waste stream in the first place. In the characteristic waste context, by contrast, the only question is, does the material still exhibit the characteristic? If you treat a characteristic waste to the point where it no longer exhibits, that it no longer fails the TCLP or is no longer ignitable, or whatever the relevant concern may be, the idea is it escapes subtitle C. There may still be some further treatment obligations under something called the land ban requirements, but that's a little bit too complicated to discuss here and now. So next slide, please. Once we have identified that we have a regulated substance, again, we regulate generators, transporters, and so-called TSDs, treatment, storage, and disposal facilities. I'm not going to talk at all about transporting requirements. They are very basic. I think very few lawyers ever deal with them. But I will talk a little bit about the requirements that apply to both generators and to TSDs. The one point I'll mention here is that TSDs are the only entities under RCRA that are required to have permits. Generators are regulated basically directly under the relevant regulations. So unlike in the NPDES world under the Clean Water Act or in the Title V world under the Clean Air Act, here you have large numbers of entities that are regulated under RCRA that don't need to have permits and that just need to look to the Code of Federal Regulations or the state equivalents to find out what the requirements are to which they are subject. Next slide, please. There are three categories of generators of hazardous waste. Fully regulated generators, those who are regulated the most pervasively, are those that generate more than 1,000 kilograms a month of hazardous waste. If you're generating liquid waste, that's about 4 55-gallon drums. Okay. EPA found a long time ago that only 2% of the generators meet this threshold out there, but they generate 99% of the hazardous waste. So that's why EPA tends to focus the most heavily on regulating these entities. It gets, if you will, the most regulatory bang for its buck in terms of making sure that these folks are doing things correctly. When we determine that total, we're looking at all of the waste, any different waste, multiple waste streams, all count in one total amount at the given facility. Facility under RCRA is defined as all contiguous property under the same ownership, not divided by a public right-of-way. So in some cases, you can have sprawling industrial facilities, or in the DoD context, you can obviously have significant military bases, that are all under the same ownership, not separated by a public right-of-way. And you need to tally up all of the different wastes that are generated at that facility. But also this status can vary from month to month. It may be that some companies have a cleanup going on and they're cleaning up contaminated soils. And so during that time period, they may be handling an unusual amount of hazardous waste, and they may qualify as fully regulated generators. But once that cleanup is done, they may revert to a much smaller status. That's completely kosher under RCRA, and that's just the way it works. Frankly, I'd be interested in hearing from Kevin and Martha on this. But my sense is most companies, if they ever think they're going to be fully regulated generators, they just meet the full requirements. It's not worth it to them to try to fine-tune things from month to month if there may be some months where they are below the relevant thresholds. Small quantity generators are kind of an interim group. They generate between 100 and 1,000 kilograms of hazardous waste per month. They have slightly relaxed requirements, but the regulations that apply to them are much closer to the fully regulated generator requirements than they are to the lowest classification. The lowest classification are so-called very small quantity generators. EPA used to call these conditionally exempt generators. It changed the phraseology a few years ago. But the idea is for folks that generate less than 100 kilograms a month of hazardous waste, we almost ignore them, frankly, we being EPA. The idea is that all they need to do is figure out what is hazardous waste that they generate. They can never accumulate more than 1,000 kilograms, and they need to send their hazardous waste either to a town dump, a Subtitle D facility, or to a facility that will legitimately reuse or reclaim them. They don't need to send their hazardous waste to a Subtitle C facility. Now, as a matter of Superfund concerns, they may think it's wise to send their waste to a Subtitle C facility, a facility that is really capable of handling their waste. But that's a matter of regulatory choice for the very small quantity generators. Next slide, please. In terms of the major requirements for the fully regulated generators, just to briefly touch on them, one is the waste determination. Again, the first and foremost obligation really is, okay, what hazardous waste do we generate and how much of each waste stream do we generate? Then there are some storage requirements. The idea is generators are allowed to store hazardous waste on site without being deemed to be storage facilities. Again, there's a much more pervasively regulated category called treatment, storage, and disposal facilities. Generally, they can store for 90 days. Okay, and the idea is you need to make sure that no single pint, no amount of whatever minimal quantity is stored on your site for more than 90 days. And actually, EPA's regulations say that if you store waste for more than 90 days, you become a TSD as a matter of law. Now, I think EPA frequently does not follow through on the implications of that statement, but it's a significant risk for business entities. I think most business entities are very, very careful about making sure they never store hazardous waste for more than 90 days. The generator is also the one that has to comply with the manifest requirements, or at least is in the lead role with regard to the manifest requirements. This is, Kevin mentioned this is a cradle to the grave scheme. This is how we track material from the cradle to the grave, from the minute it becomes a waste to the minute where it's finally treated, disposed of, incinerated, recycled, whatever it may be at the end of the day. Okay. If the generator doesn't get a signed copy of the TSD, of the manifest back from the TSD within a specified period of time, it has to report it to EPA. And then finally, the generator is the one that has to figure out what the treatment standards are that apply to its hazardous waste. Again, that pertains to something called the land ban that Congress put in 1984. And the idea is we want all hazardous waste to be treated to a significant extent before they are placed in impoundments or in landfills or in any other way in which they may potentially leach into the environment. Next slide, please. Just very quickly about TSDs. First of all, there are two very different kinds of TSDs. Some TSDs, like chemical waste management, are in the business of treating, storing, and disposing of hazardous waste, and they tend to be the most elaborate and sophisticated facilities. Then there are some manufacturers that have decided that it's in their interest to treat some of their own waste streams or to store some of their waste for more than the allowed periods, generally 90 days. But they tend to be kind of TSDs almost by accident. I mean, they have to opt in, obviously. They're engaging in activity that triggers regulation, but they're not in the business, and they don't tend to be as pervasively regulated. Unlike generators, TSDs do need to have permits or a quasi-permit status called interim status. Either way, the requirements are largely the same. The interim status regulations are in 40 CFR Part 265. The fully permitted facility standards are in Part 264, and they get put into the permits for the facilities that do have their final permits. But in any event, there's not actually a whole lot of difference between the two. The fully permitted regulations are more stringent in some aspects, but the requirements are largely the same. And one result of that is that EPA certainly does not feel a lot of time pressure to convert interim status facilities into fully permitted facilities. There are statutory deadlines that have long since lapsed, and no one seems to care. There would be an easy citizen suit to force EPA to address this, but everyone seems to agree that that would kind of be a waste of EPA's time, because in most circumstances, largely the same regulations apply, and you don't get a whole lot of extra environmental protection for what is a lot of work to convert an interim status facility into a fully permitted facility. Last slide, please. In terms of the TSD requirements that actually apply, I really only want to focus on sort of the big three that apply to many TSDs. If you're handling waste in any way in which there's any concern that it might come into contact with the ground, TSDs have to have groundwater monitoring programs in place to ensure that their facilities have not leaked. And if they detect a leak, then they go into a much more extensive groundwater monitoring program called assessment monitoring, where they have to characterize the release. That's very much like what's called a remedial investigation under CERCLA. You have a contaminated groundwater plume. We want to know what contaminants are there, in what concentrations, how fast are they moving, and where are they going. Okay, and that's going to be a very, very expensive undertaking. If you're a TSD, you just pray that you never detect a significant release from your units. Because if you do, again, your life becomes much more complicated, and your RCRA obligations become much more expensive immediately. Beyond that, every TSD has to have in place a closure plan as to how it's going to basically make it as if it never handled hazardous waste in the first place when it ceases treating, storing, and disposing of hazardous waste. Okay, some TSDs revert to generator status. That's fine. You can still generate hazardous waste, but if you've ever treated, stored, or disposed of hazardous waste, you need to have a plan in place to show how you're going to, again, doesn't necessarily mean closure of the business. It just means cessation of the TSD activities. Okay. And if you're going to leave waste in place, like if you have a hazardous waste landfill, then you need to have what's called a post-closure plan as well. How are we going to maintain that site to make sure that if it ever leaks, basically, to A, minimize the possibility of a release, but B, to make sure that if it ever leaks, we become aware of it. And that the post-closure period has to extend for at least 30 years, okay, under the regulations. And then finally, and this is important, especially with regard to closure and post-closure, we need to have financial responsibility. We don't want RCRA sites to turn into Superfund sites. So the idea is you have to set aside money in some kind of bankruptcy-proof mechanism so that you will be able to close and even go through post-closure if necessary, your site, even if your business flounders. Okay, that's called financial assurance. That part of the financial responsibility requirements. There are also financial insurance requirements, which basically are designed to ensure that there will be compensation for neighbors if they are harmed by either sudden events, explosions, fires, or the like, or what are called non-sudden events, if there are ultimately leaks from your units, your hazardous waste units, that wind up impacting their health or their drinking water supply or whatever the case may be. Thank you. You're muted, Kevin.
Thank you. We're going to move into underground storage tank. Before we do that, Professor Johnson already referenced this, but I want to make sure that we also emphasize it on its own. We're talking here about CERCLA and RCRA. I think everyone needs to recognize, though, that there are state counterparts to most all of these statutes in almost every state. CERCLA itself is not a delegated program, but there are parallel or additional state statutes similar to CERCLA in many states. I was going to say most states, but I didn't take a chance to go look at the actual chart I keep to see. But what you're going to find is California has something similar to CERCLA, Colorado, Utah, Arkansas, wherever you are, Texas has its own version of a state CERCLA program. So when we're talking about these statutes, make certain that you look at their state counterparts, because CERCLA does not, I'm spacing off on the right word, is it did not preempt the ability of states to adopt their own statutes that followed the same kind of structure. So be sure that you're aware of that. RCRA is a delegated program, as Craig has just mentioned. As of May 29th, 2024, all states and territories except for Alaska and Iowa currently have RCRA programs. So when we're talking about RCRA, you're generally talking about looking at the state regulations related to that. For that reason, as he's already said, we have in almost every state, there's some kind of specific peculiarity to that state. And in many states, they have adopted things that are much more strict than the federal standard. So make sure that you keep this in mind, and make sure you check the state counterparts with regard to both of these programs. Next slide. Along that end, we need to say something about underground storage tanks. When we were having our meeting whenever it was, we were trying to decide whether or not to even include this in this conversation today, because underground storage tanks, as I have just mentioned, are regulated under RCRA. I also have just suggested to you that in all but 2 states, RCRA is a state delegated program. So underground storage tanks vary in almost every state. We can give you some general context about these, but this is one area where you really are going to have to look at the state statute in which you're operating to make sure that you're complying with the appropriate regulation. One thing to note off the bat, typically underground storage tanks and petroleum contamination is not a CERCLA issue because of the petroleum exclusion. As I mentioned, petroleum and crude oil and its raw fractions, etc., and refined petroleum are not CERCLA hazardous, is not a CERCLA hazardous substance. So in that form, you're typically not looking at the CERCLA issues that we have talked about earlier today. There are some exceptions, the wrong word, but what you often find, for example, is a site that may have had an underground storage tank at a gas station, but was also associated with some type of a shop or facility attached to the gas station, where they use solvents, trichlor or something of that nature. The solvents also got into the groundwater and have contaminated the plume. That may arguably be a CERCLA issue because of the commingling of the contaminants. But in a normal, pure petroleum situation, this is not a CERCLA issue. Therefore, we've got to look at RCRA and the underground storage programs that have been adopted by the states. Couple of things that are different under the underground storage tank structure, generally speaking. First, the liability structure of CERCLA, and the reason I'm making such a big deal about this is not a CERCLA issue, is that liability structure for owners, operators of the property, etc., are typically not applicable under underground storage tank analysis. What you're looking for usually under an underground storage tank is who is the owner operator of the tank. The owner operator of the tank will be the party that's liable under the underground storage tank program in place. That relates to the piping as well. So note that the piping and the underground tank are all kind of considered a unit. So you want to make sure that whatever issue is associated there takes a look at the piping itself. And that becomes relevant because in many states, you can have a situation where a party believes the tank was removed, but it was removed improperly, or that the piping is still there, in which case the owner of the property may very well be the owner of the tank. So there is some overlap here. Although I said what I said with regard to CERCLA, typically speaking, if you buy the property, you buy the tank with it if it's still there. There are a number of states that take the position if it was not properly removed, it is still there, and that party can be responsible for the contamination. The other thing that I want to note here is we're talking about underground storage tanks. In many states, above ground storage tanks have become an anomaly because they're not regulated under the underground storage tank regulations. They're not a CERCLA related issue, which leaves the Clean Water Act or the water divisions in many states, state water law, to try and take care of issues associated with above ground storage tanks. The final thing I'll mention here, just in the issue of time, most states have an insurance program associated with underground storage tanks that a party can buy into. Basically, the way it will work is that a company can opt into the state program, pay a fee. I often equate it to a premium, but that's not really what they call it, and that's not the way it appears. But you opt into a program, you pay your fee, and then if there is an underground storage tank leak, party has the ability to call on the state funding program to help pay for that particular situation and remediation. So with that, let's move to the last item. Martha, do you want to talk about recent regulatory changes in PFAS?
Yeah. PFAS. Thanks, Kevin. So I'll talk about a couple upcoming developments under RCRA, and also relatedly CERCLA, actually. A couple of updates which are on the slide, and one other that I'll mention that I didn't put on the slide. But PFAS are obviously a big topic in environmental law right now, and all over the news, and high on EPA's agenda. And when I say high on EPA's agenda, I mean generally speaking, but also PFAS are one of EPA's enforcement priorities right now. So I put this in the RCRA section, but there's actually been developments that are both CERCLA and RCRA related to PFAS. So EPA recently designated both PFOA and PFOS, two types of PFAS, as hazardous substances under CERCLA. And EPA is in the process of considering whether or not to add additional PFAS as hazardous substances under CERCLA. Under RCRA, EPA in February of this past year, I believe, proposed to designate 9 PFAS as hazardous constituents under RCRA, which, if finalized, would trigger some requirements for the TSD facilities that Professor Johnston was talking about, can also be a precursor to a full hazardous waste designation. I'm going to try to address some things I've seen in the chat asking about PFAS, but on the CERCLA side, even before the designation, EPA and especially states who sometimes had broader authorities had some authority to look at PFAS. So even before the listing, we know that, for instance, EPA and states have been directing testing at some sites to see if PFAS were identified in a particular area. Also, because there are some provisions in CERCLA that are a little bit broader than those targeted at hazardous substances. PFAS had come up sometimes when peer responsible parties were conducting 5-year reviews of sites. Also, they came up in what's called the imminent and substantial endangerment provision under CERCLA, which is not targeted just at hazardous substances, but can be broader. So PFAS have been coming up already under CERCLA, but PFOA and PFOS being elevated to CERCLA hazardous substances does significantly broaden agency ability to address PFAS, past PFAS contamination. So I do think that we will see agencies start looking more for PFAS, both at new sites, but also potentially at sites that were originally designated as Superfund sites for other reasons. And that also means that new PRPs could potentially be brought into existing sites, because you could have companies that were not associated with the contaminants at issue in prior or ongoing cleanups, but could potentially be associated with PFAS. The second rule that I'll just mention very briefly is that at the same time EPA proposed to designate PFAS as hazardous constituents under RCRA, EPA also proposed a change to the regulatory definition of hazardous waste to make it a little bit broader. As Professor Johnston said, usually you look to the regulations to decide if something's a hazardous waste, and you look to see if it's either listed or characteristic. But the statutory definition of hazardous waste under RCRA is arguably broader and is tied to whether a waste would contribute to an increase in mortality or serious illness, or otherwise pose a substantial present or potential hazard to human health or the environment. And what EPA proposed to do was say, and this is really designed to address emerging contaminants like PFAS in an interim period before they might be listed or otherwise identified as a characteristic hazardous waste. But EPA is proposing to make it so that you can still trigger corrective action requirements if you meet the statutory definition of hazardous waste, even if you don't otherwise trigger the listed or characteristic definitional requirements in the current regulatory definition. The last thing I'll just mention briefly, because it's an interesting area and pertinent to the energy transition, is there's a subset of hazardous waste under RCRA that's called universal waste. An example is batteries. Those are traditionally hazardous waste, but EPA has treated them as universal waste. States have as well, because on the one hand, the risk tends to be a little bit lower, and on the other hand, usage is ubiquitous. It's not just big companies that use batteries, but everyday consumers and households. The universal designation can streamline the requirements so that they are a little bit easier to follow and create some incentives for recycling by allowing material to be accumulated for a longer period of time before disposal. Professor Johnston said normally the cutoff is 90 days, but for universal waste, it's a year. So two rulemakings that are in progress that are related to the energy transition. One is that EPA agreed last fall to take up a position to petition to designate solar panels as that would otherwise qualify as hazardous waste as universal waste. Not all solar panels are hazardous waste in the first instance, so this only impacts those that would be hazardous waste. But the idea is that it will hopefully help streamline disposal and incentivize recycling, and generally speaking, help ease end-of-life considerations for solar panels. At the same time, EPA is also developing further guidance for managing specifically EV batteries. EPA has already clarified that EV batteries are also already universal waste because they're a subset of just batteries, which are already universal waste. But EPA is working on further guidance about the management of EV batteries in particular, I think largely to address fire risk. So even though we're in the waste space, I mean, these rules do have implications as we're looking ahead to bigger picture issues like energy transition. And with that, Kevin, I think I'll turn it back over to you.
Okay, we've only got like 5 minutes, so there's a couple of questions that they're directly relevant what we were just talking about. Martha, one of the questions is, if we have one of these sites reopen that may have been closed in the past because of PFAS, are all of the generators, Professor Johnston, you too, for all of the generators that may be potentially responsible parties at that site, are they going to be liable for the PFAS if they never sent it, but it was just commingled in all of the waste on site?
Oh, Craig, you're on mute.
Craig, you're on mute.
I think there are two issues there. The first is the nature of the release that they got. And in general, almost all of EPA settlements contain a reopener for circumstances where it's later determined that the cleanup standards were not adequate. And I think there's a legal issue here, but I think it's likely that if EPA decided that we need to go back and remediate those same soils and groundwater to a greater extent because of chemicals that we didn't realize were an issue the first time around, that reopener would be triggered. But the other question is a joint and several liability question, and that is, were the PFAS materials commingled with the rest of the contamination? And if so, again, I think the burden of apportionment is going to be on any parties that sent whatever waste that was commingled in that mess. And the issue would be, is a court somehow going to look at the PFAS chemicals as being categorically different somehow in terms of the ability to apportion, despite the fact, again, that they are part of the chemical soup, if you will, at the site. And frankly, I'd be skeptical. So I would think there would be serious liability concerns for any of the generators who sent waste to that site if it's a circumstance where joint and several liability would have obtained if we had known about the PFAS chemicals in the first place.
I'll just add that I agree that I think I'd be concerned if I were a generator in that situation that liability would attach. And if you can't apportion it, then you're in the land of dealing with equitable allocation. And if you can show that you didn't send PFAS to the site, you would have strong arguments that you really shouldn't be responsible for the additional costs. The problem is you end up going through a decent amount of court procedure before you get to that point.
All right. I think we're out of time. One thing I did want to mention to the gentleman earlier that was talking about the public right of way. Ownership under CERCLA is based on a possessory property right interest as an owner. So there's a series of Ninth Circuit cases that hold that easement holders may not be CERCLA owners for ownership purposes under CERCLA. You can take a look at those. One other thing I want to mention before I thank everyone, I keep hearing that CERCLA is dead or dying. I take issue with that conclusion. I have some very good friends in the academic world who said they've stopped talking about CERCLA in their courses. I hope that's not you, Craig. But I don't think CERCLA is dead or dying, and I think that we have as vibrant of issues now that we had 20 years ago. They may not have been whether or not CERCLA is joint or several, but we have. I think the statute is alive and well. Thank you, Martha. Craig, it's a pleasure to have joined you today. I appreciate the opportunity to speak with you. I know we've got a number of unanswered questions here, but we've run out of time. So Sarah, I will turn this back to you.
Absolutely no worries. Thank you all so much. That was a lot to cover in 2 hours. So I very much admire everything that you were able to get to. And thank you all, audience. I know we couldn't get to all of your questions, but we never could get to all of the questions. You guys come up with so many amazing ones. So we appreciate you sticking it out with us. And if you couldn't attend the full webinar, it will be recorded and posted on the event webpage in a few business days. We have all of our recordings also available on our YouTube page as well. And once again, please remember to take that survey linked in the chat. It's going to be sent out to everyone via email. We would really appreciate it. It's the only way that we're able to improve these programs is if we hear from you guys directly. So thank you so much. We also have a wide variety of environmental and energy law topics in our programming throughout the year, all of which is available for free to our ELI members, as well as subscriptions to our publications, networking events, jobs boards, and even more than that. So if you're interested in becoming a member, you can find a lot more information on our websites at eli.org/associates-programs, or you can just contact Madison or I, who are both on this call, or Renee West, west@eli.org. And if you're a student, we offer complimentary membership, so definitely take advantage of that while you can. We take a summer break from educational events in August, but we do hope to see you back here again in the fall, maybe at our back to school summer school session on September 10th, which will be up soon at, again, eli.org. Thank you all and have a great day. Bye, everyone.
Bye.
Bye-bye. Thank you.